writings. Of course, being the professor and my teacher, it's you're putting me in that situation where I have to engage with my teacher and professor on the sample writings. But I think your scholarship and writings are of very high standard and quality, and no one can dispute that. They exhibit interdisciplinary comparative approaches to issues dealing with contemporary legal problems. And also, it is, I must observe that some of the writings actually deal with the issues in the judiciary. But instead of going through them, I think I'll just follow up first from where my colleagues left. You have been in academia for very long, and one of the things that troubles those of us who have interacted with other judiciaries is that the academia has not supported jurisprudential development in the judiciary, the academia which we are part of. We have been 10 years post-constitution, yet we have not had a retrospective or a reflection on where, of the kind that I would expect from serious academics, serious institutions, that tells us where we are, where we have been, and where we are going. And I compare that really like for South Africa, where even on an annual basis, you have serious scholarship on the jurisprudence of the Constitutional Court on various subjects. So as part of, and this is in the Supreme Court strategic plan, this issue of knowledge management, enhanced jurisdiction, and creating partnerships. What is it that will bring to bridge this serious gap?
Thank you very much, Commissioner. I think it's a very serious indictment to say that we have not had academics query and interrogate issues. For me, I find writing therapeutic. So when something really disturbs me, I write about it. And I would say that maybe this is happening. People are writing about different judgments, but there is no cohesion and no organized way of doing it. What I will bring to this space is the fact that I have linkages with the academy. I mean, like I keep saying that the academy in Kenya is, I can't say that there's a problem with it without owning it. So if Commissioner Majaja says we are not doing good work, then what I have to do as Chief Justice, and I've thought actually about that, is to establish ways of following trends in jurisprudence. And that would go to the question that I think it was the Chief Justice that was asking, and also Commissioner Judge Walsame, this whole issue of jurisprudence. We need to begin tracking what are the trends. And it's not just at the Supreme Court. I think even in the Court of Appeal, even in the High Court, we need to utilize the Judicial Training Institute and partner with institutions, academic institutions, to begin this introspective look. And I think 10 years is a good time.
Yes, thank you, and I look forward to that. And correct me if I'm wrong, in many of your writings, there's a writing there on constitutions as pathways to gender equality in plural legal contexts. You raise issues about the legal environment, the environment of legal pluralism that characterizes the Kenyan state. And this, I believe, has been a theme through your writing. You have the formal legal structures, and then you have the informal legal structures, the particularly Africa customary law, and other structures that support that system and the relationship between the two, particularly in issues of gender. What struck me, and again, maybe I'm wrong or I didn't read well, is that you didn't tell us how we can use the Constitution to bridge that gap between the formal and informal, particularly in developing jurisprudence, for example, like Article 20, how the courts can continue developing the law. Can you just give us an illustration of how this Constitution we have can be used to transform what you, to proceed with the decolonization project, for example?
I think in terms of the formal, informal, if you look at the jurisdiction of the court, I mean the power of the court, there is also mention of alternative dispute resolution, traditional dispute resolution, alternative justice systems. Because of the fact that I've done a lot of work, especially on the ground with women, it is very difficult to say you can use the Constitution in this one way. Because constitutions are pathways, because they will stop actions. You know, Constitution has power. So if you say, and this is the one I was talking about, the advisory on gender, if the Supreme Court had said, you cannot have those elections if we will not meet the two-thirds agenda, that would have been achieved. But when you're dealing with norms of customary law, which have, because you know they are not written, they are living and dynamic. So sometimes somebody is telling you about what the customary law is, and they are interpreting it as they go. It's the Constitution can help by, and I think the judiciary, by picking a number of spaces where these informal systems really are, and looking at how can we use the Constitution to actually bring it up. And if we don't do that, because 90% of disputes are solved outside the formal courts.
Yes, and we've made attempts, for example, to deal with some of the cultural problems we have. And a good example that has given a lot of debate, for example, I think it is accepted that having sexual intercourse with anybody under 18 is not something, as a society, we should condone. And that's why we have very strict defilement laws. And the criminal law system then moves very hard against that kind of behavior. On the other hand, you have domestic violence. Domestic violence very prevalent, and I'm sure even with this COVID, we have begun to realize that it is a bigger problem. In 2015, Parliament enacted the Protection Against Domestic Violence Act, and I'm sure you recall it. A very simple, straightforward process. If you are involved in domestic violence and you don't have to be a wife or a spouse, it covers the children, it covers a myriad of situations, wider than what we think. But in my own research, I have not found any case where this statute has been invoked by anyone. How do you explain that kind of a situation, and how, as a Chief Justice who is concerned about the broader issues of justice, you'll be the head of NCAJ, how do we deal with those kind of issues?
Thank you very much. I think the issue of having a Protection Against Domestic Violence Act will go to the context in which the violence is occurring. And domestic violence occurs within the family. And you see, even international conventions, like the Convention on the Elimination of All Forms of Discrimination Against Women, shows that dealing with infractions that happen in the family is difficult. You know, the family is at one time protective, and then at the other point, it is where you suffer most. So you can actually have a law that even accessing it, I mean, the person leaves the family to go and access this law. Where will they go back? Because there is no shielding of the person from the fallout. So in essence, I think we need to work with other justice sector actors, both state and non-state, Because you see, like with COVID-19, when people talk about when you see the statistics, you panic. It is not normal that girls who should be pregnant taking exams, but it has presented. And it may be domestic violence, maybe not domestic violence. So how do we deal with the societal issues?
Okay. Yeah. Thank you. Now, going back to the court and following up from what my colleague, the Deputy Chief Justice, talked about, and you answered, you said that you are a very dominant person. And I'm sure dominant, by the way, justified because of your intellectual heft. One of the criticisms of, whether it's right or wrong, I don't know, that the Supreme Court has faced is that we do not, they write a single judgment. You've heard of that criticism?
Yes, yes.
We are not able to gauge the intellectual position, ideological position of each individual judge and what we bring to your table. And one of the fears is we have you, Professor, coming in, going to that court and being absorbed in the ship mentality of writing joint judgments. How can you talk about that?
Thank you very much. I think when I was answering the question by the Chief Justice, I said that I will encourage judges to use their mind and pen to put out what would be what they are finding. And that, I think, is the approach that was taken by the first constitutional court in South Africa, that even if you are agreeing, let us see you are agreeing on what basis. And I think it's a very harsh judgment that you're saying ship mentality.
No, I'm just giving, you see, I'm putting to you what the critics say.
Yeah.
Yes.
But you see, I will be the Chief Justice.
Yes. So now you are reacting to that criticism.
So as the Chief Justice, I will encourage individual judges to put their mind and pen to paper. And because I will be Chief Justice, I don't expect that I will be the one writing. I will write my bit, but we will have other people working on the collective decision.
And what are the advantages of having a joint decision as opposed to separate opinions? And what are the circumstances where you decide, okay, this one I'm the Chief Justice, it is important for us to write one decision? Can you just tell us that dynamic, because you'll be going to that court?
I think the dynamic of writing one decision sort of denies people the opportunity to know what is in the mind of these other judges. And you see, that is where when you say that a person is dominant, you may have that one dominant worldview. When people write individual decisions, you're able to tell what is their jurisprudential and judicial philosophy. And I think for new courts, many times, many of those senior courts, they encourage having a joint decision. But I think it does deny the country the intellect. I mean, these are how many men and women? They are the top gray matter. We need to know what is it that they think.
Okay. Now, going now back to the issue of jurisprudence, which to the issue of jurisdiction. I think jurisdiction is what determines what the court will do. You agree with me?
Yes.
And my colleague, Commissioner Wasame, talked about this jurisdiction that keeps expanding and narrowing, what Professor Ode called the hourglass. Yes, hourglass jurisdiction. First and foremost, there's this issue of election petitions, appeals from election petitions. And in the first cases that came to the Supreme Court, the justification for taking this jurisdiction was based on the normative derivative theory. Can you explain that to us and tell us whether it is actually justified as a means of appropriating jurisdiction by the court?
I think when you're talking about normative derivative, you're looking at the fact that the Supreme Court has the mandate to look into constitutional issues. But you know, if you look at many of the things that arise, they will touch on the Constitution, some directly, others peripherally. And my view is that there are many laws, like in elections, there is the elections law. And we should aspire to end issues as much as possible there, unless there is what I think in Hermana's case is a matter of public importance, which then would justify bringing the issues to the Supreme Court.
So you're saying that, in fact, like in election petitions, the issue should not be whether it is actually a petition, but whether it raises a matter of general public importance.
Because you know when you go to election, nobody believes they will lose. And because they are time-bound, it is important to have the parties finalize their issues without having to go to the Supreme Court. Because I think the opening up of jurisdiction at the Supreme Court level opens the court also to all manner of accusations.
Yes, and that is why the proposed amendment talks about a determination of the Court of Appeal in election petition shall be final, isn't it?
Yeah.
That's what it talks about. But even when it says it is final, is there a pathway of that finality to the Supreme Court, even when the Constitution says it is final? Say, for example, in an election petition, the court interprets certain provisions of the Constitution. Do you think there is a bypass mechanism to that kind of a clause?
I don't think there is a bypass mechanism, because cases should come to an end, especially when we are saying they are time-bound. So when you begin to bypass, then it means that you're also opening up how much more time is used. That is, I think, ending the matters at the Court of Appeal would sort a lot of the issues that we're dealing with.
Okay. Now, you have done a lot of environmental law, and I'm sure you're one of the people who praised the Mitubel decision. I'm sure you're familiar with it. The Mitubel decision was about public land, primarily people occupying public land. But there's a bigger issue in Kenya. It's not so much about people occupying public land, but people occupying private land despite the proprietor. And for example, if you go to Mombasa, Malindi, that is adverse possession is the largest component of the cases. In your view, how does adverse possession, the doctrine of adverse possession, how does it relate to the issue of access to land by those who are dispossessed?
The doctrine of adverse possession is, it holds that if a person occupies the land of another without secrecy, there are three withouts.
Yes.
Then after the 12th year, then the person can actually move for adverse possession of that land.
It's a prescriptive right.
It's a prescriptive right, and I think it is informed also by, by the fact that if you have not used this land for 12 years, then it could be that you had abandoned. You know, it's really common law, it's a common law equity issue. Now, in our country, we have we have the preponderance of people on either public or private land. And sometimes you may even attempt to get them off and you can't get them off because also, you know, if you're getting them off and you're not getting in, because to deal without secrecy, I know that some people just, you scare the people away so that you can break the 12 years. I think it's Me Too Bell, for me, is a difficult decision from the Supreme Court. This whole issue of the rights that that these people who are occupying the land have. And this is because, you see, it is not a prescriptive right that they have got. They have a use right. That,
yes.
As I understood.
I just want us to go to the doctrine of recent possession. It is very much entrenched in our law. You agree with me?
Yes.
It is very much entrenched. We have established principles. And in fact, you've read the decisions of the Court of Appeal saying it does not violate Article 40. Those decisions. So I just want to read for you something in the Me Too Bell decision, and you will let me know what this means. Eh? This is what the Supreme Court said at paragraph 151 of that judgment. While we are in agreement with the submissions to the effect that an illegal occupation of private land cannot create prescriptive rights over land in favor of the occupants, we don't think that the same can be said of an illegal occupation of public land. To the contrary, we are of the considered opinion that where their landless occupy public land and establish their homes thereon, they acquire not title to that land, but to a protectable right to housing over the same. And really that was the issue, isn't it? That
yes.
If you are on public land, there is something the Constitution protects. Now, in that sentence, do you perceive that the Supreme Court was actually saying that they cannot be prescriptive rights over land?
I have grappled with that issue because, you know, prescriptive rights actually apply to private rights to
yes.
land. And this distinction between private land and public land has actually been disturbing to myself. And I think that is something that we really need to look at.
Yes. So I just want to try and tie up this issue. Now, you are a judge, and this goes to your judgment writing. It goes to the way the dispute resolved. Do you think, as a judge seated in this case, you would have made that particular sentence, because now it has left you in a lot of doubt? What about those of us who sit in the High Court?
You know, I'm sure that is not the last we are hearing of this matter. And because I have not read and canvassed all the things that I know about prescriptive rights, I'd like not to pronounce myself on that issue just now.
Okay.
But it is a problematic issue.
It is a problematic issue. Okay. Now, you taught us a lot of evidence. You were my teacher in evidence. We used to call you the evidence. Are you familiar with the case that reached the Court of Appeal on the issue of evidence? The Iranians?
No, I'm not.
Okay. Okay, that's, I'll leave that. Going into another subject, and this it's about case management. You talked about being involved in JP creating the performance indicators. And one of the things we have battled with is dealing with qualitative indicators, because people say, okay, you are now churning out the judgments. You're actually clearing cases, but we are concerned about the quality. We are concerned about the quality. What are some of the issues, and particularly since you are from academia, in terms of creating a framework for looking at the quality of decision making throughout the judiciary. Can you give us what your thinking would be? Because that is something now we want to move towards, not just the quantity, because we have done a lot of backlog. Now we want to say, okay, now with these cases we are remaining with, we want to see some quality. What is your perspective on that?
I think when we were looking at what are the trends in jurisprudence, we would need to see those trends. But I would see training as a big aspect of this qualitative and inculcation of a culture of looking out. And I know that judicial officers have researchers just looking at what is it that we are saying, what have others said, because that helps us to come with more quality judgments.
Okay. Just on the issue of training, part of the criticism we face, and even as a Judicial Service Commission we have to deal with, is the sentiment that, you know, judges you are employed to, magistrates you are employed to come and decide cases. You should not be doing training because training is a waste of time. It takes up judicial time. What is your perspective on that, and how would you answer the public?
To say that judges don't need training is actually setting them up for failure, because nobody was born, or not even a professor like myself, nobody knows all the laws. So the role of continuing judicial education is, first of all, when you, even if you are a judge of say the High Court and you became a Justice of the Supreme Court, you need to learn the culture. So induction is very critical. And then looking at areas of law that have come up. I think what we need to think about is innovative ways of making training not remove judges from what the public wants to see. And you see, what you can do is structure training rather than saying this week we are training. You know, you can have a training program that goes on for a month. A lot of the online training programs, so you say each week you do 3 hours. And so you meet the expectations of the public, but you also train the judges.
Okay. And finally on that subject, this COVID season has taught us a lot about how to conduct cases. But one of the things we are learning and we have to deal with, in fact, going forward, and just talking about our performance indicators have been affected negatively by COVID. So there is a way in which technology is a barrier of access to justice in many ways. And that is something that has to exercise the mind of the Chief Justice. How would you look into and resolve this particular issue, given the fact that the judiciary is a service institution?
I think we shouldn't make justice inaccessible through technology. But having said that, it is important to use technology as much as we can to bring justice closer to the people. We were dealing with that exact issue with teaching online, because teaching in a public university, you're saying, how do you reach the last mile? You know that Kenya is among the African countries that have very developed ICT infrastructure. And in fact, we are not called Silicon Savannah for nothing. So what I would look at is, what is the last mile and how can we meet that mile? And we can actually partner with organizations like the Communications Authority. They have Universal Service Access Funds. We see how we can access those. And also with the Ministry of ICT, to ensure that we take technology to the people. If everybody has a mobile phone, you know, in Kenya, I think the mobile phone penetration is over 95%. So the last mile is not as long.
Okay, now the final question, and this is more personal. Have you been engaged in the BBI process?
Can you define engaged?
Engaged in what way? What is your relationship either with the committee? Have you engaged with it?
You know, I was not involved in BBI at all. And the reason that I got into BBI was actually it's an interesting issue. And I was out in the village and somebody called me, said they are looking for a scholar to read this document and present it to Kenyans. And I asked, why wouldn't it be presented by the ones who wrote it? And I don't know why they couldn't pick on one of them. Your guess is as good as mine. So I actually agreed to go and read the BBI. I had a turnaround of 24 hours with a colleague and presented it. And even before Kenyans, I said, I did not write this document. I have engaged in the BBI in looking at how it affects certain constitutional provisions as a scholar. And I am currently advising Parliament on the proposed amendments. But that, again, is something that is alive before the court, and we're working on.
Yes, because one of the things you will be required to address when you are Chief Justice, or if you are Chief Justice, is the concern raised by the constituency I represent, that is the judges and magistrates, and this commission, about the amendments affecting the work of the commission in terms of bringing in the ombudsperson and the manner of determining complaints. So in your first speech coming in, how would you reassure the public and the Kenyans that you are the person that, one, this process, if it comes to fruition, will protect the independence of the judiciary, and you are the person qualified to protect the independence of the judiciary?
And you know, again, we go back to the twin issues of independence, accountability. You know, many times we approach things, and even me as a scholar, sometimes I have that tendency. You approach it without looking at it and seeing what does it really mean. If you look at the concerns about judicial independence and accountability historically, the Constitution went into a lot of efforts to ensure that these were put in the Constitution. And I think we have achieved a lot in independence, and we've moved some way in accountability. There are many mechanisms that are within the judiciary for accountability. But the only I'd like to pose the question, what is the mechanism for Wanjiku to know how accountable the judiciary is? As it is now, is the state of the judiciary address report. And is that accessible to Wanjiku? So in changing or in seeking to re-engineer the office of the judiciary ombudsperson, I think as a judiciary also we need to go to it with openness. Because if we are saying that the problem is that the appointment is X, around this table, which is also an institution that was established for bringing about accountability, there are a number of people appointed by that authority. And I think for me, what I'd say is what we want to do is to get support from the public. And you know, when you talk about accountability, answerability to the people, anything that can make us more answerable, I think, is a good thing. And I think we shouldn't go to it. But remember, we talked about interbranch relations. If interbranch relations are good, then we won't be looking at it as another way of flowing into judicial independence.
So you believe it's a good thing for the judiciary?
I think it's a good thing. Yeah.
Thank you.
Because you see, a lot was done inside. But who knows about PMMU outside there? Does Wanjiko know?
So is it the issue that this Judicial Service Commission has failed to communicate what it has done, such that we need somebody else to come and take over the issue of transparency, accountability, to be able to assist the judiciary rather than the Judicial Service Commission?
I would imagine in establishing the office of the Judiciary Ombudsperson, there would be a lot of work with the JSC. All I'm saying is that we shouldn't look at this thing in silos. We should look at what can be achieved.
You know, we should look at what can be achieved, but you know, this country has a long history, and the Judicial Service Commission, being where it is now, is a product of that history. And all we are saying is that you, as the Chief Justice, on your first day, you have to come and assure the judges, the magistrates, and the public who are concerned that, in fact, this person who is coming in to do, and if you look at the objectives, both JSC and Ombudsperson, who, by the way, you will have no control over, are doing parallel, have the same objective, doing parallel work, answerable to different institutions.
I think what I would talk about is ensuring that it is not a mechanism of looking into the judiciary from outside, that it works from within the judiciary. Like I said, if we just being appointed doesn't mean that you work alone. I don't think there is it has been elaborated, but I stand guided. I'd stand guided if the judges think that this is. So I'll think more about it. But how I had thought about it is, it's not really such a big deal.
Thank you very much, and wish you the best.
Thank you very much. I now would like to request Commissioner Jeru to go on, and then after that we have a short break.
Thank you, Prof. And my senior. Let us start with the jurisprudence. And I looked at your sample writings, and that's where I'll ask you a few questions on your legal philosophy and how you tackle jurisprudence at the Supreme Court. Now, this peer-reviewed article you did with the Oslo Law Review. Now, and you are discussing the issue of how to use the laws to realize gender equality. And what I noted is that you say that in rooting for an appreciation of the role and place of legal pluralism in promoting gender equality, the paper contends that formal laws in and of themselves are not enough to effectively deal with gender discrimination, effectively saying that they must also take into consideration our customary law and practices. And in fact, I noted that what you said is that sometimes, even when we think, even judges, when they think that you know, that they are applying the formal law, inwardly, probably sometimes they are also, you know, influenced by the customary law and practices, and they use now the formal law as the argument in enforcing certain decisions, but in actual fact, you know, they also, you know, prejudiced by the, you know, the customary law norms.